So I believe we can officially start now. Good evening, everyone, and welcome to another meeting of the Belgrade Legal Theory Group. My name is Ana Zdravkovic. I'm a PhD candidate at the Faculty of Law, University of Belgrade, and I will be your moderator for the day. It is my utmost pleasure that today we will be discussing the topic of absolute rights and proportionality. And we are truly honored that our speaker will be Professor Martin Borowski from the University of Heidelberg. Before we begin, I would just like to add that this meeting is being recorded and to remind everyone to mute themselves during the presentation, since we will have some time for the discussion and questions after the lecture. So without further ado, I now give the virtual floor to Professor Borowski. Professor, please.
Well, yes, thank you very much. I had the pleasure and the honor of having Bojan Spajic as a guest here in Heidelberg for 2 years, and I also had the benefit of being able to visit Belgrade some time ago for a week, and unfortunately now I have to do this in a digital format. But, well, thank you for having me in this seminar here, even in this digitalized form. And for the invitation to present some thoughts on how to reconcile the intuition that, on one hand, some rights are absolute, and on the other hand, that proportionality analysis determines the definitive protection granted by all rights. In short, the intuition that no right is strictly absolute. Let me emphasize from the outset that I do not aim at challenging the results of the usual doctrine of absolute rights in constitutional and international law. My question is as to whether we can justify these results more convincingly by proportionality and balancing, not by excluding it, but by using it. And I will argue that this is the case indeed. Certain rights are commonly regarded as absolute in the strict sense. That is to say, they lend themselves neither to limitation nor to proportionality analysis. Following the received opinion, absolute in the strict sense characterizes some rights found in the European Convention of Human Rights, the ECHR, namely the prohibition of torture, inhuman and degrading treatment and punishment, second, freedom from slavery, and third, human dignity. And I shall argue to the contrary that the proportionality analysis that is employed elsewhere can and should be used here too. Why so? The merit of a reconstruction of these rights in terms of proportionality analysis is the explanation that it provides, namely why it is that these rights enjoy, for all intents and purposes, an absolute standing, albeit in the form of relative absoluteness. Thus, the dogmatic, not to say a priori, character of absolute rights in the strict sense yields to an understanding of these rights in terms of the very machinery used elsewhere in proportionality analysis. And as I have already mentioned, I shall refer to this phenomenon as relative absoluteness. Proportionality analysis is widely regarded as a crucial factor in the protection of human rights. It is commonly employed as a substantive criterion for the justification of an interference with a basic right or human right. Proportionality in the broader sense comprises 3 criteria: suitability, necessity, and proportionality in its narrower sense, with the balancing requirement I shall term in what follows rights which are amenable to proportionality analysis and limitation relative rights, as opposed to absolute rights. By contrast with relative rights, absolute rights are seen as immune to limitation and therefore to proportionality analysis. It is frequently assumed in references to absolute rights that everyone knows which rights are absolute. most notably, first, the prohibition of torture, inhuman integrating treatment and punishment. Second, freedom from slavery. And third, human dignity. This is the short list. Now, the question is, what do these rights have in common that separates them from other rights? With an eye to the European Convention of Human Rights, it has been said that it is the fact that one cannot derogate from them in times of emergency, according to Article 15 ECHR. This criterion does not, however, offer a convincing explanation, since the list of non-derogable rights in Article 15 ECHR contains the right to life. Article 2 ECHR, which is not among the rights commonly considered to be absolute. Another approach that has received support in the literature is the idea that a right has to be regarded as absolute in the strict sense if the provision that records the right contains no limiting clause. This does actually apply to the rights commonly regarded as absolute. This is correct. It does also apply, however, to more than a few rights which are not on the list of the rights of, a list of absolute rights. And this is to say that none of the formal characteristics leads anywhere. By contrast, my thesis is that the characteristics of rights commonly regarded to be absolute are substantive in nature. And this substantive characterization is twofold. First, these rights protect particularly important interests of the individual, so overriding importance of the interest is the key. And second, typically no weighty limiting reason is at hand. The right generally outweighs any imaginable limiting reason by an unusually wide margin. This second element, and I think the second element is new, the second element explains why the right to life is usually not regarded as absolute, although it protects a particularly important interest of the individual, the interest not to be deprived of one's life. Plausible limiting reasons are, by all means, imaginable. Self-defense, for example, is a traditional limiting reason for the right to life. So the right to life, this right meets the first condition of the substantive characterization of an absolute right, but not the second. This is why it is not on the list traditionally. Seen as such, the idea of an absolute right in the strict sense may seem perfectly plausible. If there be an interference with an absolute right, it can never be justified. Competing rights and goods are simply irrelevant. Proportionality and balancing play no role. Full stop. To be sure, if and when absolute rights become an element of a comprehensive system of rights, which contains for the most part relative rights, then the perspective changes. To begin with, which right yields to which in instances in which two absolute rights compete? Absolute rights in the strict sense take priority by definition over every other competing right or interest. Once it has been determined that there is an interference with the right, everything else has to yield, no matter what. For example, what can be done in a situation in which the dignity of one individual can only be respected if the dignity of another individual is interfered with, and vice versa? It has been suggested in the German discussion on human dignity that a limitation of human dignity by itself be allowed. In short, this is nothing more than the admission that human dignity as an individual's legal position is not absolute in the strict sense. So this is where things begin to unravel. And it goes further. The idea of absolute rights as a part of a comprehensive system of rights, most of which are relative rights, raises the question of whether the absolute priority of every absolute right vis-à-vis every relative right, priority under all imaginable circumstances, strikes one as reasonable. Does every interference with an absolute right, however marginal, justify foregoing protection of competing relative rights, no matter how severe the consequences might be? Is it reasonable, for example, to conceive of every right commonly understood as absolute as outweighing the right to life, whatever the circumstances and the number of individuals affected? If the substantive characterization of those rights usually regarded as absolute is correct, it suggests that they be understood as subject to proportionality and balancing. From the substantive point of view, rights commonly regarded as absolute protect particularly important interests with limiting reasons that are typically far removed from justifying an interference with a right. This is to say that the interest undergirding the right is particularly weighty, and that the typical limiting reasons are usually far less weighty. Even if these rights are subjected to proportionality analysis, the result in typical circumstances is clear. The interest undergirding the right prevails, and it does so with such certainty that an express justification appears superfluous. Still, in exceptional circumstances, it may appear less certain, such that an explicit justification might seem advisable. In extreme circumstances, it might even be the case that a right commonly regarded as absolute proves actually to be limited. It militates on behalf of the relative reading of all rights that all structural problems bedeviling the reading of rights as absolute in the strict sense vanish. All the problems, the structural problems, just go away. The problem of competing so-called absolute rights, human dignity versus human dignity, for example, can be resolved from the structural point of view by balancing these rights in the circumstances of the case at hand. These are the hard cases. For particularly important interests are at stake on both sides of the issue. To be sure, balancing provides a structure in which normative problems can be decided in an open and transparent manner. In addition, the hardly reasonable assumption that every absolute right takes priority over every relative right in every instance disappears. The rights commonly regarded as absolute rights and those regarded as relative rights can be balanced. The strict priority of absolute rights over relative rights is replaced by a very strong prima facie priority of absolute rights. Very strong, but surmountable in exceptional cases. Still, even if the relative reading of the rights commonly regarded as absolute should avoid a number of problems, a pressing question remains. Does it not tend to undermine the protection granted by these rights? Does one find oneself in wrong company, in company of people arguing in favor of waterboarding or other instances of torture? I shall repeat my emphasis from the beginning that the relative reading of the rights commonly regarded as absolute proposed in this lecture is neither intended to weaken the protection these rights provide, nor, I believe, does it in fact weaken them. Even if the rights commonly regarded as absolute were to lose their structural characteristic, that is, being technically immune to proportionality and analysis, their substantive characteristics, paramount abstract weight, and typically far less weighty limiting reasons would remain. It is widely recognized that the rights commonly regarded as absolute deserve a particularly high level of protection, and this universally accepted conviction is to be taken seriously. A relative reading is suggested here to offer a more convincing reconstruction of this high level of protection and to solve structural paradoxes to which the absolute reading in the strict sense gives rise. It is not, for a third time to repeat this, is not offered to change the results of the common understanding. And this, I think, needs to be emphasized, for a relative reading of absolute rights might also be employed for wrong reasons. Employed as a means in what I shall term a debate that is result-oriented. Result-oriented debates are characterized by the effort to justify a result that departs from the received opinion. Let us say that someone is simply convinced that in certain life-threatening situations, state action, usually classified as an instance of torture, can, by way of exception, be justified. The Geithgen case, which was decided by the Grand Chamber of the European Court of Human Rights in 2010, 11 years ago now already, may serve as an example. A law student in Frankfurt, Magnus Geithgen, kidnapped an 11-year-old boy, Jakob von Metzler. It's also referred to as the von Metzler case, holding him for ransom money. After taking the ransom, the law student was apprehended by the police. The police had assumed that the boy was still alive and that he was, of course, in imminent danger, possibly dying of thirst, helplessly locked away in a hideout. Geithgen refused to reveal the boy's whereabouts. The police chief in Frankfurt, Wolfgang Daschner, so it's also the Daschner case, the three names are used for the very same case, Wolfgang Daschner threatened the suspect with intolerable pain inflicted by a special police squad already underway in a helicopter, which was a lie. There are no such police squads in Germany, at least none we know of. Under medical supervision, to make this look a bit more official. Having been exposed to the threats for roughly 10 minutes, Geithgen revealed the location of the corpse. It turned out that the boy had died earlier of suffocation. So there was no one to rescue, actually. This case sparked a lively debate on how far the police are allowed to go in a situation in which it is reasonable to assume that the life of an innocent victim may well be in imminent danger. According to the Grand Chamber of the European Court of Human Rights, the treatment to which Geithgen was exposed amounted to inhuman treatment and so counted as a violation of Article 3 of the European Convention of Human Rights. In a result-oriented debate, this is what is now to be illustrated here. In a result-oriented debate, a certain outcome of the case is taken as the Archimedean point. A paradigmatic statement in a result-oriented debate on the Geithgen case might read as follows. Quote, in the Geithgen case, Daschner's course of action must be permitted. Close quote. Those who support this thesis and disagree with the result of the Grand Chamber judgment now can choose between two strategies to explain why, according to their opinion, the treatment to which Geithgen was exposed does not violate Article 3 ECHR. they can claim, first, that the treatment as such is not an instance of torture or inhuman or degrading treatment or punishment, according to Article 3 ECHR in the first place. So it doesn't count as a case under these, to be subsumed under these definitions. And here the euphemism of a forced interrogation, allegedly just short of torture, springs to mind. The first strategy. The second strategy is that it actually is an instance of such treatment, torture, inhuman or degrading treatment, but that it is, as an exception, justified in the circumstances of the case at hand. Now, what is relevant here in our context is that it is a necessary element of this second strategy that the absolute nature of Article 3 ECHR is denied. If an exception or limitation can be made, this right cannot be, by definition, absolute. This is to say that the relative nature of this certain right may well become part of the result-oriented debate. Where it does, however, it serves only as a means to an end, as a means of supporting a certain outcome in the case that is taken as given from the outset. Now, the key problem of this strategy is, of course, whether the conviction regarding the outcome of the case, the Archimedean point of the results-oriented debate, is in fact justified. Where does it come from? How do you argue with people who disagree with this initial conviction? Apart from this very general but important problem, there are serious doubts as to whether a relative reading of Article 3 ECHR really can support the thesis that Daschner's course of action in the Geithgen case was actually justified. I will return to this issue in the later part of this lecture. Rules on attributing weight to competing principles with rising severity of interference and the consideration of the certainty of empirical premises, taken together, these two elements, serve to explain why it is mistaken to suppose that subjecting absolute rights to proportionality analysis would diminish their significance. To begin with, rights commonly regarded to be absolute have a particularly high abstract weight. Second, in balancing, the relation between the intensity of interference and the weight of the relevant principle is not proportional. That is, to justify a more severe interference with a right, one requires a justification far stronger than merely a proportionately stronger justification. This phenomenon is the more pronounced, the higher the abstract weight of the relevant right. Since rights commonly regarded as absolute have a particularly high abstract weight, any interference with them will count as a very severe interference. This is to say that only limiting reasons that can even come close to outweigh them are those of truly outstanding importance. Third, the third element, severe interferences have to be based on empirical premises, empirical knowledge that are certain, knowledge that is certain. Very severe interferences have to be based on very certain empirical premises. These intuitions suggest the following. The more severe the interference with the right, the greater the required certainty of the empirical premises. And the idea of a disproportionate increase also applies here. The more severe the interference and the higher the abstract weight of the relevant right, right in question, the disproportionately greater the certainty of the empirical premises is required. This is to say that an interference with the rights commonly regarded as absolute, for which a particularly high abstract weight is typical, they can only be justified by limiting reasons with, first, truly outstanding weight, and second, on the basis of absolutely certain empirical premises. The crucial role of the certainty of empirical premises in balancing can also be illustrated by an analysis of the notorious ticking time bomb case. The supporters of torture frequently refer to an artificial case in which a terrorist has planted a bomb and is the only one who can defuse it in time. The facts are always arranged in such a way as to lead to a great many casualties unless the terrorist is subjected to measures that are usually classified as torture. The idea is to orchestrate a situation in such a way that the prohibition of torture is juxtaposed with competing rights and interests that are as weighty as possible. And then a rhetorical question is supposed to emerge. Who would not be prepared to endorse some form of torture, mild form of torture, when so many lives are at stake? It is important to understand that such hypothetical or artificial cases have, however, much less in common with real cases than torture supporters would have us believe. All empirical uncertainties are simply removed by way of hypothetical assumption. The terrorist is the terrorist, not a suspected terrorist. It is certain that no one else can defuse the bomb in a timely fashion. It is certain that the terrorist will disclose the crucial information under some allegedly mild form of torture. It is certain that this information will save a great many lives, and so on. The introduction of these empirical assumptions does not count as some kind of generous simplification. Rather, it changes the case fundamentally. The role of the certainty in empirical premises and balancing explains why hypothetical or artificial scenarios tell us very little about how to decide real cases. The idea of relative absoluteness of the high level of protection for some rights brought about by balancing is not simply a theoretical idea. In the case law of the German Federal Constitutional Court, one finds two different strands of argument in assessing claims stemming from human dignity. The first strand is the absolute strand. In these judgments, the court explicitly rules out any proportionality analysis or balancing of human dignity. The second strand, however, is relative. Here the court uses arguments that are characteristic of balancing. In some judgments, you find even both strands of the very same judgment. For example, in the judgment on the statutory empowerment to shoot down passenger aircraft in cases of terroristic attacks, the 9/11 situation. The relativity of the prohibition of torture in human integrating treatment and punishment, Article 3 ECHR, to which the court in Strasbourg repeatedly referred, goes in the very same relative direction. To illustrate the plausibility of the idea of relative absoluteness, it is well to revisit the Geithgen case. What changes if this approach is compared with the traditional understanding of absolute rights? In line with the traditional understanding and the case law of the European Court of Human Rights in Strasbourg, the Grand Chamber emphasizes the absolute nature of Article 3 ECHR and explicitly rules out any balancing. If, however, one applies proportionality, does the outcome change? Does the fact that the life of a child was supposedly at stake justify the treatment to which Geithgen was subjected? It is plausible to assume that the treatment accorded to Geithgen amounted to an interference with Article 3 ECHR. He was in police custody and handcuffed, which represents a situation of particular vulnerability and constraint. And he was threatened with unbearable pain, and this, according to the usual phrases the Strasbourg court uses for subsumption under the conditions, they were fulfilled. There can be little doubt that this counts as a very severe interference with Geithgen's interests. The responsible police officer, Daschner, pursued the end of saving the life of the missing boy. In principle, the boy's right to life, Article 2 ECHR, served as a limiting reason. It's a legitimate end. And I leave aside problems at the suitability and necessity stage. One could have a word on that, but let's only look at balancing. The interference with Geithgen's right not to be subjected to inhuman treatment according to Article 3 ECHR is indeed very severe, and the negative effects on Geithgen were absolutely certain. The presumption against such interference can be rebutted only if extraordinary limiting reasons are forthcoming, and in substantive terms, of course, the life of a child is of inestimable value. However, it was far from certain that torturing Geithgen would save the life of the boy. The police officer could not be absolutely certain that they had the right man in custody. They could not be certain that Geithgen knew where the boy was hidden, and they could not be sure that the boy was still alive. Taking all of these empirical uncertainties together, Daschner's course of action appears to have been an act of desperation, rather than an act reflecting a sound empirical basis. And this, in my view, tips the balance decisively in favor of Geithgen and his right according to Article 3 ECHR. Of course, we do not like him, but this is not to say that his interests are not worthy of being respected. And this can be generalized where two particularly important substantive interests, such as the interest to life and the interest not to be subjected to torture in human degrading treatment, compete. The certainty of empirical premises very often decides the outcome. And the negative effects of torture and inhuman and degrading treatment are absolutely certain. It is hardly imaginable to regard Article 3 ECHR as ever being outweighed. Finally, the question arises as to whether uncoupling proportionality and limitation might serve as a compromise between absolute and relative rights. It has been mentioned that where paradigmatically limitable rights are applied, proportionality analysis is conducted at the level of the justification of the interference. That is, in determining whether a right is limited. One could, however, think of using proportionality elsewhere in the scheme of assessment of rights claims as a criterion for the determination of whether there is an interference with the right in the first place. In the Anglo-Saxon literature, this is sometimes referred to as definitional balancing. Balancing defines what torture or inhuman treatment actually is. Does this uncoupling, does this give rise to an absolute right because illimitable, that is susceptible to proportionality analysis? The answer is negative. The only difference here is that the limitation is hidden. That uncoupling proportionality and limitation may well be more than a theoretical construct can be illustrated by the case law of the ECTHR and the German Federal Constitutional Court. And the structural characteristics of such an approach can also be illustrated by analyzing Robert Alexi's reconstruction of human dignity in the German Basic Law. It has already been mentioned that the determination of the scope of absolute rights in the strict sense carries the whole burden of their assessment, and that there is necessarily a tendency towards a narrow scope. It does not come as a surprise that only serious maltreatment of individuals can amount to interference of Article 3 ECHR. In Ireland and United Kingdom, the Strasbourg Court coined a phrase according to which the assessment of whether there is a violation is relative in nature. And it underscored this nature in the Geithgen case. And then there are some arguments to construe this as a relative right. But there was then a turn back in the absolute direction in the Shahal case and in Zadi, two cases in which balancing that was referred to in Geithgen was actually ruled out as a misconception of that precedent. And this absolute line is continued in the Strasbourg Court's judgment on Geithgen. Commentators are divided. There are simply some people understanding these precedents in an absolute fashion. Others are more inclined to the idea that there's some balancing going on. And of course, any analysis of the court's case law is a topic in and of itself and goes well beyond the scope of this presentation. But I think it's important to sum up in some way to say that there are two reconstructions of the Strasbourg Court's case law that are possible. The first reconstruction is that the court uses actually proportionality balancing for the determination of whether there is an interference with the Article 3 ECHR. So it uses definitional balancing. And this is to say that the required severity for a violation depends on the weight of the competing rights or interests. And in this case, if this is true, Article 3 ECHR is absolute in the sense that it cannot be expressly limited. It is, however, relative in the sense that proportionality analysis is part of the assessment of the rights claim. First reconstruction. Now, the second is the court does not use proportionality balancing in the application of Article 3 ECHR, not as a criterion for a limitation, and not in the determination of whether there is an interference with the right either. And on this reading, Article 3 ECHR is absolute in every sense. Neither a limitation nor the application of proportionality is possible. The relativity formula of the Strasbourg Court, this is, I think, important. The relativity formula in and of itself permits both readings. It's not only the absolute reading, which is possible. And this is to say, which reconstruction is correct depends on how this formula is actually applied. And Geithgen points in the relative direction, as already mentioned, Shahal and following decisions in the absolute. Geithgen is actually compatible with both readings, interestingly, although it seems on first glance to support the absolute reading a bit more. Anyway, it is hard, in my view, it is hard to imagine that the court is completely unimpressed by competing rights and interests in the assessment of claims invoking Article 3 ECHR, and this points toward the relative reconstruction. This, I think, could also be undergirded by considerations on legal argumentation in general, but this is something probably or possibly for the discussion. The case law of the German Federal Constitutional Court, interestingly, is split too, just as the Strasbourg Court's precedents. And there are also two different lines of decision. Decisions in which the court emphasizes the absolute nature, and the second strand, a relative strand, in which the German court actually uses balancing considerations in justifying the outcome of the case at hand. Commentators in Germany, well, there's the orthodox view of human dignity as an absolute right in the strict sense, but it is losing support among commentators, and the idea of balancing in the assessment of claims based on human dignity is on the advance. And just a couple of words on Robert Alexis' reconstruction, because I think this is paradigmatic for what is going on here in the case law. In an attempt to reconcile the absolute with the relative strand in the case law, in the German Federal Constitutional Court's case law, Robert Alexis distinguished in his 1985 monograph, A Theory of Constitutional Rights, 36 years ago, English translation from 2002, he distinguished between two elements of human dignity, the human dignity principle and the human dignity rule. And he emphasized the semantic open texture of the concept of human dignity. The human dignity rule establishes, he continued, the definitive protection granted by Article 1.1 German Basic Law. The human dignity principle undergirds the human dignity rule, and the human dignity principle is balanced against competing rights or interests. The rule is the result of this balancing. In Alexis' words, quote, the preference relation between the human dignity principle and other competing principles determines the content of the human dignity rule. Close quote. According to Alexis' principles theory, the application of principle necessarily requires proportionality analysis. The nature of principles implies the proportionality principle. The advantage of this reconstruction, Alexis concluded, is that on one hand, no limiting clause needs to be read into the human dignity norm of the Constitution, but that on the other hand, human dignity principle can still be balanced with other constitutional principles. In short, one can have proportionality without limitation. In a recent paper, 2015, Alexis referred to this idea as the dual construction of human dignity. This dual construction, the model of implicit proportionality analysis in the assessment of rights claims invoking human dignity, renders Article 1.1 German Basic Law absolute in some sense, in the sense that once the human dignity rule has been established, no exception, justification, or balancing is possible. It presupposes human dignity as relative, however, insofar as the principle of human dignity is balanced according to proportionality in actually determining the rule of human dignity. If Alexis considers proportionality analysis without express limitation as advantageous, he uses this very word, advantageous, the question rises as to why it ought to be advantageous for human dignity alone rather than for all constitutional rights. If it is a good strategy, why only use it for human dignity, not for all other basic rights, constitutional rights, human rights, and so on? For example, if people are barred from attending religious services owing to an imminent pandemic, one might ask whether a principle of religious freedom and a rule of religious freedom ought to be distinguished, the latter, the rule, being absolute in nature. The principle of religious freedom needs to be balanced against competing principles in the circumstances of the case at hand. In the case of the pandemic, public health. Public health outweighs religious freedom, in short. We can discuss that, but maybe not today. So that people have no definitive right to attend religious services. It is crucial to understand that the application of proportionality to rights is in both cases, open limitation or definitional balancing, is in both cases precisely the same. A prima facie right, the principle, is balanced against competing rights and interests, and the outcome of the balancing is the definitive right. The difference is that the standard model of limitable rights focuses on the prima facie right and on the justification of interferences, while Alexis' reconstruction of human dignity, the dual construction, in the sense of implicit proportionality analysis, places the definitive right center stage. One could say that if judges were to follow Alexis' model of human dignity, it would be less obvious that they are performing proportionality balancing. To put a sharp edge on it, is it advantageous is it advantageous to hide the fact that proportionality analysis takes place in assessing claims stemming from basic rights? Considering that it is regarded as a crucial advantage of proportionality balancing, that it sheds light on the relevant premises and particularly on the justification of the weight of the competing principles, the answer must be negative. Alexei recently replied to this criticism by saying that using his model in order to hide the fact that balancing takes place would be a misuse of his model. He refers to what he calls the dominance proposition, according to which the human dignity principle takes precedence over the human dignity rule, the latter being completely dependent on the former. My point is, however, that the very structure of the dual construction makes such a use easier, and that fact is not changed by simply saying that this dual construction must not be misused. What is more, and this is my last substantive point, I'm inclined to uphold an additional aspect of my earlier criticism of Alexei's model, namely that the issue of formal criteria, such as prescribed by law, is not reflected. It is not understood that implicit proportionality analysis in the semantic open texture of the human dignity rule counts as an instance of limitation in the sense of the standard model of limitable rights. This is to say that there are no formal criteria in Alexei's dual construction of human dignity. If this is taken seriously, it is to say that the executive or the judiciary does not require any prior authorization by parliamentary statute to consider the human dignity principle as being outweighed in a given case. If the rights that follow the standard model of limitable rights, if they require such prior authorization by parliamentary statute, why would human dignity, which is characterized by significantly higher abstract weight, not require it? To conclude, uncoupling proportionality and limitation does not give rise, in my view, to a new structural model of basic rights that offers an advantage. The main difference, by comparison with the standard model, is that the limitation of the prima facie right is hidden rather than explicitly acknowledged, and that no formal protection is afforded. Since rendering the balancing and the arguments in support of it transparent is a crucial advantage of proportionality analysis, the shift in the focus that results from the dual construction of human dignity is, in my view, unfortunate. So, is the idea of proportionality analysis in the application of so-called absolute rights a wrong turn, as Stephanie Palmer from Cambridge would have us believe? There are good reasons to doubt this. In fact, the results most of us regard as correct can be better reconstructed by means of balancing. And the role of the certainty of empirical premises in balancing explains why hypothetical or artificial scenarios tell us very little about how to decide real cases. If all this is true, it suggests itself to replace blanket absoluteness in the form of the category of absolute rights in the strict sense, with all the paradoxes and problems it creates, with a relative reading of the rights commonly regarded to be absolute. Thank you for your kind attention.
Thank you, Professor, for this quite interesting presentation. You really gave us a feast of ideas. And now I invite everyone to engage and provide us with their comments and questions. As I wrote in a chat box, you can ask questions by raising your virtual hand. So the discussion part of the meeting is now officially open. Okay, so since I do not see any hands yet, I will use this opportunity, if you don't mind, of course, to make a few comments myself. So first of all, my first comment is about the limitation clause that you have mentioned, particularly in regard to the convention system. Although it is true that there is no limitation clause in certain provisions of the convention, such as the right to education, which you mentioned in the paper, or Article 5, we have to consider the case law of the court in this regard. So the court did say, for example, in the case of Leyla Shahin versus Turkey in 2005, that the right to education is not absolute, but on the contrary, because of its nature, it can be limited and it is relative. And the same goes for the Article 5 and also for the protection of property, which are all provisions without the limitation clause. So with that being said, I wouldn't necessarily exclude those formal criteria for identification of absolute rights. And this is, of course, does not mean that I'm rejecting the thesis of applying proportionality to absolute rights, since I completely accept the idea. And finally, there is no denying that we have seen the court applying balancing in regard to the Article 3. But I just wanted to emphasize that I am still not convinced with rejecting those formal criteria. In the same manner, when it comes to the right to life, I would like to add that I completely agree with the stand that it cannot be considered absolute. Taking into account the wording of Article 2 of the European Convention and all those exceptions that are laid down in that provision. However, I personally believe that we can interpret Article 2 in a way that it absolutely prohibits arbitrary deprivation of life. Hence, the right not to be arbitrarily deprived of life is, at least from my point of view, an absolute right. And this is, if I'm not mistaken, in line with the restriction of the rationality deficit that you mentioned in the paper. So if we accept this kind of interpretation of Article 2 and the right to life, then I don't see why we wouldn't consider that Article 15, which mentions derogations and non-derogable rights of the Convention, is indeed somehow indicating rights that are absolute. So maybe you can also comment on that. Thank you.
Well, thank you very much. With an eye to the two questions or questions/remarks you made. With the formal protection thing, we have, of course, in the European Convention, express limiting clauses in Article 8, 9, 10, and 11, paragraph 2, which explicitly require prescribed by law. And I completely agree that it is perfectly possible, and there are good arguments on behalf of the idea, that if you have implied limitation without an express limiting clause, but if you say the same structure applies to rights who are granted provisions without an express limiting clause, to require also here by analogiam that you need prescribed by law also for these cases you mentioned, Shaheen, the right to education, Article 5, and property in the additional protocol, the first, and so on. Now, the problem is not that the problem is not that you cannot have this formal protection if it is not explicitly provided for in a written clause. You can have formal protection by way of interpretation in these implied cases of limitation. I agree wholeheartedly, and this is the German doctrine of interpreting German constitutional rights, the very same doctrine. We have rights without express limitation clause, and the Gesetzesvorbehalt, which translates into something like, you understand German, I see, it requires also for the vorbehaltlose Grundrechte, as they are called in Germany, the constitutional rights without express limitation clause. The problem with Robert Alexi's reconstruction is not that he says wrong things. He has not yet replied to this issue that his reconstruction may circumvent formal protection. The problem is that he doesn't mention it at all. And the consequences in the German doctrine, because this formal protection required by law in the German reconstruction of constitutional rights, Eingriff-Schrankenschema, because formal protection is located on the side of the justification. If you do the definitional balancing thing, then there is no limitation. Because what usually happens at the stage of the justification of the interference, the balancing, already happens while you are assessing whether this is a case of inhuman treatment. And it's just an open question what he would do on that count, and he has not yet replied. So I would be very much in favor, if I were to support Robert Alexi's idea, I would urge him very strongly to include formal protection in his model and say, well, yes, there's not only the substantive requirement of balancing, proportionality, and definitional balancing, but there is also formal protection. But the question then is first, where does it apply? Because there is no express justification. It has to be in the definitional bit of the assessment of claims. And of course, the question arises even stronger. Why does he use his model and not the standard model if the very same criteria apply? So I think you pointed out correctly an issue, but in my view, this is very much for Robert Alexi to explain to us what he would do with the element of formal protection in his model. Now, if I say his model has problems because he doesn't say something on this, and I would argue on behalf of the standard model, the formal protection would be there because it would be an explicit justification that depends on formal protection prescribed by law and proportionality. Your first point. The second point, you refer to Article 2 as an absolute right because you said it's an absolute right not to be deprived arbitrarily of your life. Now, the very point is, in my view, arbitrarily is, in my view, a reference to proportionality, or at least at the beginning to some rough form of proportionality coupled with a generous extent of discretion. It's a relatively low level of review. Is proportionality seen through a lens of a very low intensity of review, I would argue, arbitrarily. Now, my point, so to speak, countering your point, would be that it doesn't make, from the structural point of view, this is not supposed to sound too harsh, but for the sake of clarity, it does not make much sense to say that once you have applied proportionality, a right is absolute. Because once you have gone through the process of proportionality analysis, there is a definitive result, which may be wrong or right, or well justified or less well justified, but you have come to a conclusion. You have arrived at a definitive odd statement. And then once you have arrived at the definitive statement, of course, you can't balance anymore because you have already done so. So in this view, I would say that arbitrarily in Article 2 serves as a reference for limitation proportionality analysis. And so in that sense, Article 2 is a relative right. And then, of course, the your argument continuing that actually the list in Article 15 contains only absolute rights, then I would say, well, if you insist on Article 2 arbitrarily, this is an absolute right, it is a completely different absolute right compared to Article 3, Article 4, and what is in the European Charter and in the German Constitution, human dignity. So it would be a completely different kind of being absolute.
Thank you so much. This was really important for me and for my arguments in the thesis. If we have time after, maybe we can come back, but I want, of course, to let others make their comments. I see that Professor Spajic raised a hand, so Professor, please.
Thank you, Anna. Thank you, Martin, for the wonderful presentation. It was the first time I read it, and it still is, of course, a very interesting paper because it does one thing that I didn't thought possible, because this idea of absolute rights rings to me as something, even if it's the topic of Anna's PhD work, rings as something that I always find somehow a bit implausible at the outset. So if your paper does anything, is practically it rescues the term, for me at least. I know it's not like that for all the other people, and actually I wanted to ask the question after Anna asked hers, because it ties in well. Of course, me being doing philosophy of law, it's of course more general than Anna's. Me, it's like with philosophers always, it's that I don't have enough relevant data about that's the usual reason for the general character of questions. But it's kind of this question that I, when discussing proportionality or legal principles, it can be really, I think, translated to this issue: which rights are absolute and which rights are relative, if we disregard this element that you call formal, but basically it's just this written element of, so you have it in writing that one right is can be restricted by law or something like that, in a similar formulation. When we switch from these formal criteria and you call or written exceptions to rights that can be enacted by law to these substantive criteria, we, I think, or a question at least can be asked, reach a problem of, is there any way to claim that a right is absolute absent a prior proportionality reasoning, for example? If I'm making myself clear. So it's kind of a similar problem when you talk about rules and principles, and of course you probably get these questions, so at least you were getting it a lot earlier. How do we recognize that something is a rule and that something is a principle? So it's basically, how do we recognize, in absence of a formal criteria, that something is an absolute right and something is not an absolute human right? I'm not sure that this problem can be solved, but of course it's an interesting issue for me. The second point is also akin to Anna's comment about the interpretation of this. The problem, as it goes, the problem with interpretations is they usually add stuff. So it's possible that they don't add stuff, but all the interpretations that I know of add things. And the issue here is, interpretatively, when it comes to changing the form of the text of, for example, the European Constitution of Human Rights, Article 3, and making it out to be absolute or making it out to be relative, the options there seem quite open when it comes to interpreting the articles. And I guess I lost now. So the strand of this question, but the idea is it turns back to practically the previous question. It turns back to the previous question, and it comes around to this issue whether we can recognize absolute rights before a court has reasoned with those rights, either by proportionality or by subsumption, if that be the case. So that would be it. If it comes around this second part of the question, I'll make sure to raise my hand. Sorry for the fuss about this second question.
Well, thank you. And I was just thinking while you were phrasing your second question, while it was emerging between us, among us, I thought actually that it has something to do with your first question, because of course we at the beginning of an interpretation, and the answer to the first question is interpretation. The first thing we encounter is a text, is a provision. And well, human dignity has been stretched, so to speak, as an example here too. If you think in the context of legal philosophy, if you think about the Radbruch formula, you may well remember that after the German reunification, the border shootings were criminally prosecuted. There were border guards of the East German entity, which claimed itself to be a state, and people were shot trying to flee this entity to the West. And they were basically rewarded when they successfully shot people at the border and prevented them from fleeing the so-called Republic, German Democratic Republic, as it was called. They were rewarded. There was no criminal punishment. There was no criminal investigation. Now, after the German reunification, there were quite a few of these cases, actually, and they had quite some publicity in the West because they happened at the border, Berlin or the other border, and they were recorded by West German border guards. And after the reunification, these former East German border guards were prosecuted for homicide. And at the end of the day, we leave the legal philosophy part, the Radbruch formula part here out for a moment. My only point here is there is of course a constitutional provision in the German constitution that criminal punishment requires that there is a prior criminal statute. Is this retroactive punishment? And the question was the requirement of this prior parliamentary statute, criminal statute, for being able to prosecute someone was considered to be absolute as a rule. And then the German Federal Constitutional Court kind of did not directly address the issue, but they said, well, this is absolute, and this is absolute in normal circumstances, but not for such rogue states as the former East German Republic. And in these cases, it does not apply. So by way of interpretation, an exception was introduced in interpretation, and depending on how you construe it, it's now a relative provision, or there is an exception that was not known beforehand. In some sense, as I think to quote you from your second question, stuff is added. And the stuff here is the exception, the unwritten exception that is added to it. And the same applies to every constitutional provision if we are asking ourselves, is this a rule or is this a principle? Because we are asking ourselves, are there actually is it necessary to balance? Is it, and of course then the usual canons of interpretation come into play. Is it actually the original intent of the framers of the Constitution that this is being subject to balancing? Or is this something that is supposed to be absolute? And if so, what actually was it precisely that they regarded to be absolutely protected? This would be, of course, important too. Not only that it is absolute, but what is absolute? Because you cannot meaningfully determine whether something is absolute without determining what this something actually is. And by all means, interpretation plays the crucial role here too. Now, if you are a textualist, for example, if you are a textualist, you would argue with an eye to the implicit limiting clauses. So the limiting clauses that are not written, or the provisions of the Constitution that do not contain an express limiting clause. As a textualist, you would always argue, well, there is a Constitution, and this Constitution knows express limiting clauses. Now, the constitutional framers added limiting clauses to some rights, but to other rights, they decided not to add a limiting clause. So we are not supposed to consider that these other rights are actually limitable. So as a textualist, you would argue, well, there's no way. We have to respect the express distinction of the constitutional framers, which rights are limitable and which are not. You can feel this kind of somewhat bad conscience in the phrases of the German Constitutional Court when they introduced these unwritten limiting clauses, because they limited the set of legitimate interests, because they say this is only rights of others and principles that are explicitly provided for in the Constitution. While for those rights with written limiting clauses, there are additional grounds of limitation, unlimited grounds of limitation. And so the bad conscience, so to speak, found expression in they say, well, yeah, you can do it, but this, in contrast to these rights with written limiting clauses, there's only a limited set of reasons you may use. Although, to be honest, this supposedly limited set of limiting reason proved in the practice of the interpretation to be actually limitless, because there's no single case of the German Constitutional Court known where there was from an intuitive approach to what would serve as a substantively legitimate limiting reason, which they did not find in the Constitution somewhere, or even indirectly. And the same story, in some sense, happened at a very different place in the context of the market freedoms of the European Union, because the market freedoms formally have a structure that also has an area of application, a scope, and an interference, and there is justification, and there is balancing going on. And so even for the market freedoms, there are limiting clauses. Some have a limiting clause, some do not. Some have a set of limiting clauses with a limited list of limiting reasons. But the story at the end of the day was where there was a legitimate need perceived, they just added something to the list with all sorts of different justifications. So the answer is interpretation goes on, stuff is added. Yes, a textualist would have difficulty in finding these unwritten limiting clauses, but what we just experienced in the interpretation of constitutional rights, of ECHR rights, not rights of the Charter of Fundamental Rights, because it has a general limiting clause. This is a different story, and I think is the end point of this development, because they just saw, well, we don't fuss about limiting clauses anymore, because there is one if we need one. So we just go with this general limiting clause. This basically shows, Bojan, those who were at work were not textualists, to say the least. But yes, they added significantly, they added significant stuff in interpreting these provisions. And this is something you have to do. Because even if you say, I actually refuse explicitly to accept an unwritten limiting clause, you're also adding stuff.
Yeah, thank you. I believe we have time for one more question. Theodora, you raised your hand. Please speak up.
Yes, thank you for your presentation. I have a question in regard to what you mentioned in your paper. So proportionality in the narrow sense, as you wrote, deems the interference as disproportionate if it overweights the promotion of the legitimate aim pursued by authorities. So as you mentioned, there could be stalemate cases where actually, as you said, the legitimate aim doesn't have to actually overweight the interference. There could be stalemate. Now, you mentioned Alexei discusses that. So in theory, yes, there could be stalemate, but in practice, especially in the European Court of Human Rights law practice, I don't think we can actually see that stalemate within the decisions. But what I'm asking essentially, because you said that from that derives that the government has the authorities have the benefit of the doubt when it comes to legitimate aims. So, and that's the substantive issue, in your opinion. My question is, what can we learn from, what can we derive from that substantive nature of the benefit of the doubt? That's first. And secondly, I understand that European Court, giving benefit of the doubt to the authorities is nothing new in the jurisprudence of the European Court. They don't only apply it in the proportionality. They also, for example, Article 18 until recently gave the benefit of the doubt to the authorities, and I understand why, because of the principle of subsidiarity, for example. But my question is, in national constitutional case law, do you think that actually, I'm not familiar, do you think there are cases and countries in which this benefit of the doubt is not given to the authorities or essentially the government? Thank you.
Well, thank you. An important issue we are approaching is stalemates, structural discretion, epistemic discretion, a huge field, but I think it is possible to meaningfully say something here rather at the end of a discussion. Now you said you don't see much of a stalemate in justifications of courts. This may have two reasons. It may have two reasons. May have the reason that the court is actually taking an approach according to which what Alexei calls infinitesimal scaling is possible. That means that we can distinguish on a scale which is very, very, very fine, and that we attribute a kind of utility, costs, prices, numbers, something like we have a balancing between freedom of press and privacy of an individual. Some photos are taken and published. It's a kind of a standard balancing exercise. Many cases are known, and you can say, well, this is on the one side we have 77.2, on the other side we have 78.8. This would become close to infinitesimal scaling. Now, Robert Alexei, in his analysis of balancing, has proposed limited scaling. And he says, well, this is not something we can do because we do not have methods of measuring such fine distinctions. And he proposes something like we only can distinguish between a light interference, a medium interference, and a severe interference. Now, it doesn't have to be 3 stages. It can be 5. It can be very light, medium, severe, very severe. It can be 7. It can be 13, or whatever. It depends on how how confident you are that you can meaningfully justify different levels of severity. Now, if you have infinitesimal scaling, there will be hardly ever be any stalemates. So stalemates vanish. Now, this is the substantive reason why courts may just assume there must be infinitesimal scaling. It may also be that they understand that there is not infinitesimal scaling, but they tend to hide it because it sounds a bit undetermined to say, well, we don't know. We expect judges to know something. So this is the more, so to speak, rhetoric, culture justification, dependent justification of how judges express their judgments. I don't know. You would have to analyze the respective jurisdiction and the precedents to see which of these explanations is true. Now, the benefit of the doubt, it has, I think, something that Robert Alexei unfortunately is not doing, is explicitly distinguishing between what I would call, what do I call them actually? I've forgotten. Well, the second category is review balancing, Kontrollabwägung, and in German the first is Ausgangsabwägung. It means something like the first balancing. Why? Because when we do a reconstruction of balancing, we can reconstruct when, for example, there is legislation going on. The parliament is actually balancing because parliament thinks if they do, there's a reform of the press statute, they may actually consider what is actually constitutionally possible, what can we do in terms of statutes to demarcate what the press is supposed to do and how do we phrase that in our judgment. Then the legislator is actually balancing. Now, if there is a stalemate and the legislator is balancing, the stalemate for the legislator means freedom. Because in the stalemate, whatever the legislator does, he is not violating the Constitution. Now, when it comes to the review balancing of the Constitutional Court, the perspective changes. Why? Because if the Constitutional Court is now empowered to review the balancing decision of the legislator, the Constitutional Court is supposed only to annul the legislator's statute if the legislator's statute violates the Constitution. Now, in the stalemate, no decision of the legislator violates the Constitution. So in the stalemate case, the discretion that emerges, even in the review decision of the Constitutional Court, is discretion for the legislator. And this is the benefit of the doubt. And this very fact that we all have naturally assumed for decades without any asking for any express justification or explanation is, I think, in my view, an institutional expression of the principle of democracy, because the legislator is directly democratically legitimated. If it comes to stalemate cases, it is for the legislator. And so the benefit of the doubt is, so to speak, built into the system and its basic assumptions, but is an expression of democracy. Now, your second question, or the last part of your question, as I may call it, asked me whether there is actually a national system without this benefit of the doubt. I'm, of course, not competent to speak of all, of course not all, and not even many national systems. In the German system, I can tell you, we have this democratic benefit of the doubt, as we just discussed it, and we also have another element, which is also part of the margin of appreciation the European Court of Human Rights grants to the member states. That is some discretion to the courts that performed balancing judgment before the European, the ECTHR in Strasbourg comes into play. So it's very present in the German system. I would argue it's even far more present than in the Strasbourg system. And I have recently tried to focus my attention a little bit on the similarities between the German system and the Strasbourg system, because we have analyzed the German problem, these two sides of the problem, and I think they are part and parcel, these two, the democratic problem and the problem of balancing competences distributed among national courts. These structures are both part of the international law phenomenon of the margin of appreciation of the Strasbourg Court. And of course, there's even more discretion for the Strasbourg Court because it's discretion for the member state in general. So I think it's greater discretion than the national system has. I'm not, as I said, I'm not competent on the details of other nations, not even our neighbors here geographically. But I think one answer is possible because of this stalemate, the structural discretion, the stalemate problem, that the review decision, that in a stalemate it has to respect the democratic decision of the parliament. I would be very surprised if this is not in any form part of a national system, what I would call the Western type liberal democracy. So I've probably yes is my answer. Thank you.
Okay, thank you. Well, since we are out of time, I would just like to thank you, Professor, once again. It was really an honor, and you gave us a lot to think about. And also to thank everyone for being here with us today. We hope to see you on the next meeting of the Belgrade Legal Theory Group. So until next time, stay safe.